I'd like to dedicate my newest contribution to our dear Elpis V Law Review to the memory of Maestro Giuseppe Sinopoli, a brilliant musician and contributor to European culture, as well as a polymath, having been active also in other scientific fields, and Maestro Sinopoli died almost 25 years ago. The topic of the EU Ombudsman fits perfectly well into the overall topic of weakness and effectiveness of the law of the present Elpis V Law Review. On the one hand, the Ombudsman addresses weaknesses which occur through maladministration in the European Union's institutional context, and on the other hand, through his or her actions, the Ombudsman has a solid contribution, after all, to the rule of law within the European Union. There are various names within the EU member states for the institution discussed here. While the original Scandinavian term Ombudsman is encountered, as well as Bürgerbeauftragter in German language, the Greek designation, Evropeus Diamesolavitis, which means a European mediator, is arguably the most accurate in terms of its meaning. This is because the word meson, meaning middle, reveals the ideal and fundamental goal of the institution of the Ombudsman, namely the effective mediating, indeed conciliatory role between EU citizens in particular and the EU institutions with regard to administrative matters. Furthermore, the institution of the EU Ombudsman can certainly be seen as being descended from ancient Hellenic institutions, for instance, if one remembers the 10 Epthini from Athens and the Ephori from Sparta. The office of the European Union Ombudsman is still relatively young, being a product of the Maastricht Treaty. Its creation, however, followed a period spanning approximately 2 decades and involving tough negotiations. The first office holder was a Scandinavian, Jakob Söderman from Finland, who served from 1995 to 2003, and of course, given the office's, as I mentioned before, implicit Scandinavian roots also, it was perhaps only natural that the first office holder came from that geographical region. Söderman was then followed by Professor Nikiforos Diamandouros from 2003 to 2013, mirroring what I said about the fact that the European Union Ombudsman is very well descending also from ancient Hellenic institutions, so it was apparent that the second Ombudsman would be a Greek citizen. Since 2013, the office was held by the Irish woman Emily O'Reilly, and in early 2025, Teresa Anjinho of Portugal succeeded her. Article 228 of the Treaty on the Functioning of the European Union is the legal basis to the EU Ombudsman. Following this basis, the Ombudsman is elected directly by the EU Parliament for a renewable office term of 5 years. He or she acts independently and impartially, holding EU institutions accountable and promoting good administrative practices, having in mind Article 41 of the EU Charter of Fundamental Rights, which emphasizes the European citizens' right to a good administration, as well as their right to refer to the Ombudsman directly based on Article 43 of the same Charter. The Ombudsman hence assists individuals, but also businesses and organizations with problems they might encounter with European Union administrative bodies by investigating complaints about maladministration. He or she, the EU Ombudsman, may also act ex officio. Besides Article 228 TFEU, Regulation 2021/1163, laying down regulations and general conditions governing the performance of the Ombudsman's duties, is applied in this context, as well as the 2023 decision of the European Union Ombudsman adopting certain implementing provisions. Besides of significance for intra-European collaboration and cooperation is also the fact that the European Ombudsman must, where appropriate, collaborate with the relevant national authorities without overlapping their respective remits, of course. This fundamental approach is undoubtedly the basis for the so-called European Network of Ombudspeople. This network has proven its worth in practice, particularly through in-depth subject-specific seminars, as well as relevant publications. Perhaps the most important legal instrument at the Ombudsman's disposal is the European Code of Good Administrative Behavior, adopted by the European Parliament. This code explicitly reaffirms the right to lodge a complaint with the European Ombudsman, and at the very beginning of the code, in its Article 1, the scope of application is fundamentally defined. The most important principles to be observed by bodies and officials in their relations with the public, as set out in the aforementioned code, are, to name the most important ones, the principle of legality, the principle of non-discrimination, proportionality, the non-abuse of power, matters of impartiality and independence, objectivity, fairness, and, of course, courtesy. Although statistically spoken, the European Commission is in reality the main subject of complaints to the European Ombudsman, a number of other EU institutions has also been the subject of such appeals to date. An interesting example is, for instance, that the Office for Harmonization within the internal market agreed, in response to the Ombudsman's relevant investigation, to change its language policy by agreeing firstly to accept written inquiries from EU citizens in all official EU languages and to reply to the letters in the respective language of the citizens, and secondly to make its homepage available in all official EU languages. That happened following the relevant actions of the EU Ombudsman back then. Furthermore, the European Medicines Agency has also been the subject of various investigations by the Ombudsman, particularly due to the sensitivity of the topic of European public health. In one case, this very agency agreed to make reports on suspected serious side effects of a pharmaceutical product publicly available. In another case, it granted public access to documents on certain medical products and decided to implement and to publish a new policy that would make documents in its possession easier accessible to a much wider public. Besides, the European Economic and Social Committee endeavored to rectify a relatively serious blunder as follows. It agreed to pay the complainant in a certain case a certain sum as financial compensation for the expenses that complainant incurred after the committee had mistakenly informed her that she had been selected for a job. In the context of the issue of filling various positions within EU institutions, the Ombudsman's mediating activity was further highly productive. The European Personnel Selection Office, for example, agreed to grant all applicants, and not only those who were unsuccessful, access to their examination results. In an even more recent case, the complainant requested the European Commission to give public access to a risk assessment report by a large social media platform concerning the crucial matter of its compliance with the Digital Services Act. Such annual reporting, as you know, is part of the obligations of so-called very large online platforms over the aforementioned Act. The Commission first refused access to the report, citing a certain exception under the EU legislation on public access to documents. And following the activity of the Ombudsman and her team in this context, the Ombudsman informed the Commission of her view that it was inappropriate to apply a presumption of non-disclosure to such a risk assessment report. And under these circumstances, the Commission granted access to the relevant report. Overall, having a look at relevant numbers and following the Ombudsman report for 2024, which was issued in April of 2025. In the year 2023, EU institutions cooperated satisfactorily with the Ombudsman in 82% of instances. Of the 92 proposals the Ombudsman made to correct and to improve their administrative practices, EU institutions reacted positively to 75 of them. The Office of the European Ombudsman has undoubtedly grown and become more prominent over the past decades. The courageous work of all the previous ombudspeople has contributed significantly to this, not least because of enhanced media communication resources, which is particularly evident, of course, in the European Ombudsman's very informative and very comprehensive website. The practical examples cited before from the Ombudsman's work, of which there are many more to be considered, show that his or her activities do not go unnoticed by the European Union institutions concerned. On the contrary, these institutions strive to consolidate their standing with regard to the rule of law in the eyes of the European public as effectively and as efficiently as possible. Nevertheless, It will continue to require considerable effort from all parties involved to make the Ombudsman's office even more accessible to all European Union citizens and other potential complainants in order to eliminate certain information deficits that still exist in this regard. The new Ombudsman will have a great deal of work to do in this respect, but no effort is too great for the progress of a European rule of law.